of walking back without spending countless hours in traffic.
I dream of living in a community where my parents feel loved at a later age.
I dream of spending weekends with my loved ones, staying relaxed and stress-free.
I dream of living in a town where my kids can walk back home from school without any hassle.
These simple dreams can now be a reality with Brigade Orchards. Ranked amongst India's top 3 smart townships, Brigade Orchards is spread across 130 acres of lush greenery and urban facilities to create the perfect synergy between nature and developments. Ideally located just 10 minutes away from the Bengaluru International Airport in Devanahalli, Brigade Orchards offers a completely self-sustained life for you and your entire family. The stimulating experience begins right from the moment you enter Brigade Orchards. The architectural planning, broad roads, and tropical landscaping will leave you with absolute tranquility. The township offers an array of residential options to choose from, like our luxurious 4-bedroom pavilion villas. Spacious 2 and 3-bedroom apartments, and our special managed villa services for your convenience. We've dedicated time, energy, and passion to provide the perfect blend of sophistication and serenity for our residents. It also hosts numerous developments amidst the lush green orchards like commercial and retail spaces, school and healthcare facilities, senior citizens housing, and a multifaceted signature club and resort for your leisure. Our fully functional signature club has the finest amenities, including a spa, swimming pool, gym, indoor courts for squash and badminton, fine dining restaurant, and more for your entertainment. Along with state-of-the-art conferencing facilities with luxury rooms and suites for our corporate delegates. At the center of the property is the exquisitely designed world-class sports arena for all your recreational needs. You don't have to wait any longer to pursue your dreams with sports like
Hello.
Hello,
Hi.
can you hear me?
Yes, I'm able to hear you. Are you able to hear me?
Yes. I just want to know.
Yes, please.
Hi, good morning, everyone. Thank you for joining on this webinar. I am Mihir Shah from Services for NRI. I am a director of Services for NRI. Services for NRI has been registered in UK since 2013, and we help NRIs and OCIs like you to do a property transaction back home in India, to get a home loan for Indian property. We also assist in a lot of taxation work relating to India, legal work relating to India. And today, that's the whole idea about this webinar, and make you understand about what are the rules and regulation about tax, about legal, if you're looking for a property loan, home loan, and everything. So we have a three speaker this today morning. First of all, we have a Nehal Varu. Hi, Nehal, can we see you?
Yeah, hi, Mihir.
Hi. So Nehal is with HDFC Limited at the Home Loan, HDFC Home Loan London office. They have office in London since 2006, and they help NRIs and OCIs to get loan. So she will explain to you further on that. Then we have Abhay Maniyar. Abhay, who is a practicing chartered accountant in Mumbai over a 2 decade now. And Abhay takes care of all the accounting, NRI related accounting work and all those things. Abhay, can we see us?
Yeah. Hello, everyone.
Yeah.
Hello, Mihir.
Hi, thanks, Abhay. And we have a Monisha Mahajan. She's a High Court lawyer, and she's been practicing over 15 years now for the NRI matters, and she's based out of Chandigarh. Monisha, can we see us?
Yeah, hi guys.
Thank you, everyone. So now, first of all, Nehal, to you, please explain what the HDFC can help us sitting out in London for people who are looking for a loan.
Hi, Mihir. Thank you for having us here, and thank you everyone for joining us on a Saturday morning. To just give you a brief background about HDFC London office, as Mihir rightly said, we've been based here since 2006. And we've been providing advisory services for people holding OCIs, NRIs, and PIOs. So if you're looking for buying a property in India and you're looking for a home loan, then we provide advisory services locally here. We also offer balance transfer of loans. So if you have an existing loan with any other lender, and if you're looking to refinance that loan, we consider that also. And our rate of interest is currently starting from 6.7 onwards, and it depends on a couple of factors regarding your credit score, your credit history, and loan amount and other factors. We also help you in terms of property. So in case if you want to understand if the particular property is approved or not with HDFC, and if you want any further assistance in getting it approved before you apply for a loan, we can help you with that as well. We also help you to go for a pre-approved loan. So in case if you haven't shortlisted the property, but you just want to understand your eligibility, and if you want to go for a pre-approved loan and finalize the property at a later stage, we offer pre-approved loans as well. So if you have any questions in terms of if you're looking for a home loan, if you were looking for a refinance, anything related to the property approval, you can get in touch with us. Our contact details will be shared by Mihir shortly. So
I know there are a lot of questions are going to come up, but we'll keep the question answer session at last. So thanks for the brief introduction, and thanks about explaining to us the whole the role of HDFC Home Loan London office. Thank you for understanding. Now over to you, Abhay. Abhay, I just want to understand the TDS aspect on purchase, on sale of property, capital gains, and if the person have sell the property, and after selling the property, if they want to bring money to send money to abroad, how the whole aspect works. So if you can explain to us, people who want to understand this thing.
Surely, Mihir. So good morning, friends, everyone. Let's hope we all are in good health. We would be discussing mainly for this taxation of NRI, focusing mainly for the capital gains transactions, and that too out of the sale of immovable property, and points connected to the same. Let's with the beginning, just to start with the very basic point of, when we say NRI, the non-resident Indian, it is mainly on the basis of the physical or your number of days stay in India. So as we know, everybody 182 days and all those basic things, everybody would be surely aware of. One thing, please be careful of, if your annual income is more than 15 lakhs in a year, ensure to monitor your number of days stay in India. If it exceeds more than 120 days, in that particular case, you will be termed as resident. This one in specific point I wanted to bring to your notice. Moving ahead from the resident status, I would say let us start with this PAN application. This is something very basic question which we have been asked for once this was been released. So people wanted to know what would be a basic flow or the process of applying for PAN number from UK or from abroad. So what we understand and the new process for this PAN application is, first of all, you need to have relevant documents, physical documents made available, especially your passports, your OCI card, your address proof of foreign land, and your bank statement, which will be having the same postal address. These physical copies has to be sent to either our India office or a relevant professional from whom you approach for the PAN application. The official fees of the government is 1,020 rupees, that is including GST. When you have an address of foreign land, if you have a place which is a permanent place of residence in India, then the fees charged by the government is 110. Whatever the additional professional fees would be charged would be extra. This would be a specific case where you ensure that all your documents are properly been signed, self-attested, as well as the form has to be signed with black color ink pen. A very basic thing I wanted to bring to your notice. Most of the people try to have an adventure of trying on their own. It is always good. We prefer people doing that. But my advice would be, please always take a help of a professional, because there are still few operational issues which a professional into his day-to-day actions help you to solve these issues and get the any kind of your applications quicker. Let's quickly jump on to the TDS on sale of property, which is very exciting for everyone, where people are very concerned about when an NRI sells his property or her property in India, what are the things and how it has been tackled by the legislation or the tax laws. Over here, there are two ways. One is you allow the buyer to deduct your TDS on the amount of full sale consideration. So please be aware, if you sell as an NRI, if anything of any immovable property is being sold, the TDS will be deducted on full sale consideration. Now the TDS amount over here is going to be if it is long term or short term. So we need to decide on the criteria is when you are selling a property, the holding period of that property. If it is more than 2 years, it is termed as long term capital gains. If it is lesser than 2 years, it falls into short term capital gain. Now, why we need to do this? There are different rate of taxes in both the scenarios. In long term capital gains, you are charged at 20% plus surcharge and cess. Surcharge depends upon the slab rates. And short-term capital gains, you are charged at 30% TDS. Alternatively, another form is you need to apply in Form 13. As an NRI, a person should apply to the income tax officer asking for the lower rate of tax deduction. This is only applicable when your capital gains amount is much lower than the sales consideration. This is a process which is always again advisable to route through a professional who guides you with the relevant types of documents. I would just brief you few of the documents that is needed when you apply for Form 13, which is required for tax exemption certificate, we call it. Your sale agreement, your purchase agreements, your mode of payments. These certain documents are to be gathered and submitted to the professional for further submission. This process is also online, but yes, it needs some kind of an intervention by the professional to help you to get this route also quicker. It gives you approximately a month's time to get this certificate. It can be expedited with various means. Whereas when we allow the buyer to deduct full rate of TDS, in the previous format that we have discussed, the TDS can be deducted at full rate and the NRI can later on file his income tax returns and claim that as a refund. Refund normally post filing return, you may normally get the refund in 2 to 3 months. But this would be like if you sell a property for, say, example, in the month of May. In India, we have financial year, everybody is aware, from April to March. So your eligibility to file the income tax return would be somewhere in the month of June or July of the next year, financial year. So your refund processing will happen after July. So if you have been selling in, say, May 21, your return would be filed in June 22. You expect, your refund in something called as September or August or September 22. Here your working capital is blocked or whatever, the funds would be blocked for that much period. But our experience in this last couple of years, refunds are processed faster. But yes, a huge amount of funds is blocked. So the option is with the NRI or the SSE, option which one to choose. Specific, if I get into the forms, while the deduction is the responsibility of the buyer. So here when we are talking the scenario is a buyer is a resident and the seller is a non-resident. In this case, the buyer has to avail TAN number. This TAN number is something different than the PAN number just to be applied for. Here we'll just get into little nitty-gritty about the returns goes quarterly, but the payments has to be made monthly. The payments of TDS has to be following as per the advances paid as well as at the time of agreement. So please ensure that the TDS is deducted as and when the payments are being made. Again, repeating, the responsibilities of the buyer and not of the seller. Here the buyer is a resident and the seller is a non-resident. In the same case, if we go vice versa, if the seller is intending to buy the property and the buyer is an NRI and the seller is a resident, in this case, the NRI has to deduct tax at 1% if the property value is 50 lakhs. That is not the case when the seller is an NRI. There is no eligibility amount. Even 10 lakhs rupees of a property will attract the TDS amount. This is something relating to the buying and selling of property. When we say about once the property is sold and there is some repatriation of funds coming from India, one basic thing which would be needed will always be about your 15 CACB. We call it as a form which should be issued by a professional, a chartered accountant, which will be handed over to the banker, against which the banker is then authorized to or allowed to repatriate the funds outside India. We'll get into the logic, and the specific reason is the bankers just need to have, as an authorized dealer, just need to know the source of fund. Is it being properly tax paid fund? So if the certification normally will only ask for the mention about the source of the funds of this particular balance lying in NRO account or NRI account, which will be repatriated outside India, valid amount of tax is being paid. You have to approach, there are two forms, 15CA and 15CB. 15CA, the assessee or the NRI himself or herself can do it from the online. Still, I again say, please approach the professional. Don't try adventure with any tax laws or any operations. 15CB has to be compulsorily issued by a chartered accountant. By submitting this form, you will be allowed to repatriate the funds from India.
Sorry to interrupt you there, but can you just explain the capital gains laws, because how that is calculated? That's more important aspect. And we just about 2-3 minutes for you to speak further on that. Sorry.
Yes, I was just a little worried because I'm just trying to rush because we have limitation of time. If the taxation, if you look at the capital gains, if I go through the capital gains aspect, as I said, short-term and long-term capital gains which has been taxed. I will focus on the long-term capital gains working, where your cost of purchase will be allowed to be as a deducted expenditure out of from the consideration what you have received. This cost of purchase, there is something called as indexation, which will increase the cost value. That depends upon the number of years which you have purchased the property and when you are selling it. So that indexation benefit can be claimed by the assessee or the NRI while depositing the tax. So in capital gains, for the long-term capital gains, the tax rates are 20%. plus surcharge and cess as applicable. Cess is 4% and surcharge varies from 10% to up to the mark of 37% on the value of capital gains. Over here, the capital gain is calculated, just repeating, sales consideration reduced with the cost of purchase. Now here the cost of purchase, you can also add up any improvement cost if it has been done on that property. Say example, if I buy a flat and if I spend some 5 lakh rupees on its renovation, that is an eligible expenditure which you can allow to be reduced while computing your capital gains. Any kind of, even your legal expenditures, your payment of brokerage can also be reduced. Your stamp duty registration also forms part of your cost of acquisition. So we use the word cost of acquisition and cost of improvement. Both these costs are eligible costs to be reduced from the sales considerations. The tax will be charged to you, sales consideration, reducing cost of acquisition and cost of improvement. The balance amount is being taxed. Here, if we say there can be tax saving tools available, I will jump on that, saying that Section 54 of Income Tax Act, Section 54F of the Income Tax Act, and Section 54 EC. These are the tax saving tools where you reinvest the amount which you have gained out of selling the flats, reinvesting into residential plots, residential flats, that is residential properties, or you can invest into tax saving capital gain saving bonds, especially rural electrical and national highway bonds. Here the national highway bonds, again, 3 years holding locking is compulsory. The interest earned out of those bonds are taxable interest income, as well as whenever you buy a property against sale of this property, that also need to be held for minimum 3 years. If you sell that property or if you sell those bonds within 3 years, the amount which was supposed to be taxed paid in the first year will be deferred and to be paid in that particular year.
Yeah, thank you, Abhay. Yes, I can see there are a lot of questions coming in. Just to let you know, everyone, we will answer all those questions by end of this webinar, by once everyone has spoken about it. And if we haven't covered your point, then definitely my team will connect to you one-to-one to resolve those things. Now to Monisha. Hi, Monisha. You're on mute, Monisha. Sorry.
So Mihir, I'll introduce myself as well.
Please go ahead.
Yeah, hi guys, I'm Monisha Mahajan. I run this boutique law firm where I'm sure some of you already are our existing clients, called Legal Help NRI, which has been serving and assisting non-resident Indians across the globe. We've got a local office in Harrow. Me and Mihir work together. So we work on anything with the non-resident Indians, right from obtaining documents to transfers to cases to litigation to sale of property, repatriation, so forth and so on. And of course, what Abhay said was really helpful. In fact, I had certain questions which he addressed in his little time that he took. Anyways, guys, so as I understand, I'm not going to be very technical. I am going to mix my language, which is going to be Hindi and English, so everybody can understand. So the reason I'm here, I'm going to pick up 3 things. Most of our people who are our audience today happen to be non-resident Indians who've got assets in India or are building assets in India or have got some issue here or there, or they have their roots connected to India somewhere or the other. So I'm hoping that these 5-7 minutes that I'll take will be of help to you and will give you a little clarity on certain things which everybody has questions about. And in fact, during this COVID times, the service that we provide is for non-resident Indians, where our clients do not have to travel to India. Now, during this COVID times, it came to me as this thing that actually this is one service that what we've been providing people is something which they required all the more reason during COVID. And I'm going to cover up those points, the services that we provided to people during COVID times. So yes, I'm going to take up 3 things that people have constant and regular questions on. One is the power of attorney. Second is the wills. And third is for people who've invested money with some developers and are facing issues regarding getting their possession, or there is delayed possession, or there is escalation of cost. Now, my first point is your power of attorney. We get constant queries, and of course a lot of people pop into the office in Harrow saying that we want to get a power of attorney done, and we want to sell our property through the power of attorney, or we need to give it to a relative or a friend for some issue or the other. What is a power of attorney? Now, the name is very clear in itself. It's a power given to an attorney. Now, the reason how you are taking up the power of attorney and what purpose you are giving the power of attorney is exceptionally important, and is the only important point that you need to realize when giving this document. Power of attorney is you're giving all your powers to a person. Now, when you give it to somebody for selling your property, the person has complete right to sell the property on the basis of that one single piece of paper. So anytime and every time a person who's a non-resident Indian is giving a power of attorney, couple of things I always tell, there are a couple of videos we've done on YouTube or on our website. If you read our website, we've done articles, is power of attorney, very specific. Jis purpose ke liye de rahe ho, keep it, stick to that purpose. Don't make it general. Because a general power of attorney is, let's say you want to give somebody to rent your property, right? Give it for purposes of renting. Agar tenant ka naam pata hai, to give it that I'm giving this power of attorney for renting for this particular, to this particular person, and the rent will come into my account. Give your account number. Do not just give a power of attorney, okay, I'm giving it to my cousin or my brother or my father or my mother or whomsoever you're giving. You might trust the person 100%. But what happens if that power of attorney is stolen from the house and somebody tries to misuse it? So why not, when you are in a country where you are so particular and specific about doing certain things, why do you not follow the same process when you're issuing a document for India? Please document it well, get it read, reread, and reviewed by a lawyer. Second thing, we get this constant thing, do we need to do a power of attorney on a stamp paper? No. When you're doing a power of attorney from a foreign country, it does not need to be on a stamp paper. It's on a plain piece of paper. It needs to be notarized. It needs to be attested by the FCO or the Indian High Commission, whichever you are able to get done, depending on where you're located in England. That needs to be done. Now, every state in India has a specific requirement for a power of attorney by an NRI. Punjab is very different. Gujarat is different. Mumbai is different. MP is different. Some people want thumb impressions. Some authorities don't require thumb impressions. Some require a thumb impression on the picture, stamping on the picture. So, before you issue a document like as important as a power of attorney, advice of a lawyer, reviewed by a lawyer, understand every word of that document before issuing it, and then send it to India. Again, there are a lot of technicalities. It's not just signing and sending a document, ho gaya nahi. Udhar India mein aake bhi, there are a lot of processes that have to be followed to make that document applicable. Now, this is about power of attorney. I've just given you a snapshot of what a power of attorney is and how you should be doing a power of attorney. For any specific questions, you can put it on the chat or write to me here. Now, secondly is your will. Now, I don't know if some of you are facing an issue with wills or not, but what has happened in my experience of 20 years of catering to the NRI community, a lot of people for their Indian estate either don't make wills or assume that agar हमने will बना दिया है UK में, that will is valid in India. This is a very confusing point, and with too many frauds and the real estate and the appreciation of properties in India, it has led to far more disputes than you guys can imagine. A will is a document. The reason of making a will was a wish of a person. It is as simple as that. Somebody could just write it on a piece of paper and that was a will. But now today, when you want to talk about a property and estate, people who are aged, people who have estate in India should, in my opinion, make a separate will for the Indian estate. Do not mix a will for your Indian estate with it. You can mention it in your UK will that we've got assets in India for which a separate will is made, or you can mention, then your lawyer in India and the lawyer in UK should work in collaboration when making a complete planning your estate. It is very important because what happens is people do up wills in UK. Now I'll give you an example of a client that we're working for. A will is done in UK. Father made a will, father died, father gave everything to the mother. Mother died, mother gave everything to the son. Now there are two witnesses to the will, which is the lawyer, his secretary, and the third person is a local friend. They don't know who he is. For a will to be proved in India, for if you have to get anything transferred in India, especially in states like Gujarat and Maharashtra, a probate of the will has to be obtained. Let's say if you've done a will in the UK, uska probate ki copy aap yahan leke aoge, that probate has to be authenticated in India through an order of the court. Now for all that purpose, आपको वो witness भी चाहिए है जिसने वो will करी थी, attest करी थी, and you have to prove that the will is a valid document, because of course, let's say a father gives the main chunk of the property to a son and leaves behind a daughter or doesn't give anything to the other son. The second son is going to challenge it. He's going to say this will is all nonsense, I don't accept this will, prove karo. Aap prove kaise karoge? You can only prove the will through the attesting witnesses. So, like, I'll go back to the first thing. When you're doing a will for your Indian estate, do take an advice of a lawyer. Very important. Like you do for a power of attorney, will is a very important document. As you take it seriously for UK, it should be taken for the Indian estate. Indian properties today are as expensive or probably more expensive than UK. That is one. Secondly, the way things are managed in India, the things are dealt in India are very different than UK. The courts here, of course, because of people who are not a person's absence, and the procedural aspect in India is very different. So let's make it very simple for people who are there, who feel कि हाँ हमारा estate है, हमने उसके बच्चों को देके जाना है, या एक बेटे को देना है, दूसरे बेटे को नहीं देना, या बेटी को देना है, नहीं देना, वाइफ को देना है, जिसको भी देना है, put it on a piece of paper. Do it as per your do it as per the Indian laws. Mention it that there is a separate will for the property in UK or whatever. All that can be done. It can be done while you are in UK. You don't have to specially come to India to register the will, because people will say, "Hum jab India aayenge, hum tab kara lenge." With COVID times, yes, we've done, like me and Mihir have done so many wills for people, because everybody became a little scared of what if something happens to them. And sadly, we've had a client who made a will and he passed away in 3 months. So yes, we do deal with these issues, and it comes out totally out of my experience of dealing with people's assets and estate in India. So will banao, power of attorney batao, experts की advice लो. Just don't take it for granted कि India देख लेंगे, because उसके बाद जब आप देखते हो वो 10 साल 20 साल जो कहते हैं इंडिया में तारीख पे तारीख है, 10 साल 20 साल निकल जाते हैं, because we've taken Indian procedures also for granted. So estate, power of attorney and wills both have to be with advice of a lawyer, done in a prescribed format. Then I'm sure a lot of people will have questions regarding their bonds and succession certificates, etc. Again, please send your specific query, because I can speak endlessly on this topic. We deal with succession certificates. Succession certificate is not for immovable properties. I'll just say that, because I'm sure everybody will be like, हमें succession certificate किसी ने बोला है property के लिए लेने के लिए. No, succession certificate again has nothing to do with whether you have a will or not, and it is not for your land or your house. It is only for your bank accounts, your fixed deposits, or any movable assets. Now, third thing that I'm going to pick up is a lot of people who have invested with developers and builders are still struggling with getting back their possession. अभी तक possession मिला नहीं. Getting back है delayed possession है. 10 साल हो गए, 5 साल हो गए, 3 साल हो गए, द बिल्डर से आज हो जाएगा, कोविड टाइम्स हो गए, 6 महीने का एक्सटेंशन हो गया, नहीं हो पा रहा. And this has been endless with a lot of developers. There are some developers who have become bankrupt, and what is that group? I forgot. Supertech happens to be one of them. and a lot of people have invested with Supertech. So, does a person who's living abroad and who's invested with a buyer, let's say 5 years ago, 10 years ago, does he have a remedy? And let's say he's paying the interest and everything, क्या कर सकता है वो? इतने अच्छा हमारा इंडियन सिस्टम है एंड वी गॉट सच अमेजिंग रेमेडीज. यस, उसको थोड़ा प्रोसेस करने में टाइम लग जाता है, बट देर आर रेमेडीज. If strongly represented, there is no chance that you will not get back your money. So the authorities are RERA. Mihir has already talked about them, and that every project today, कोई भी builder करता है, he has to register with RERA. Let's say you have invested in a project which was not invested, who's not enlisted or registered with RERA. What happens to them? उसका क्या कर सकते हो? Then you have options like the consumer court. Now both these authorities today are so quick in relief giving, because if you look at the spectrum of and gamut of judgments which has come out for against the developers, that they have to pay on a daily basis in case there is a delay on possession. They pay you interest. आपका पैसा ही नहीं वापस होता, आपको इंटरेस्ट भी मिलता है, आपको डैमेजेस भी मिलते हैं. सो ये सोच के कि हम बाहर बैठे हैं, अब वापस इंडिया आएंगे और तब केस फाइल करेंगे, नथिंग लाइक दैट. आई एम श्योर कोविड हैज मेड पीपल अवेयर ऑफ दैट. यू डोंट नीड टू बी फिजिकली प्रेजेंट एवरीवेयर. वर्चुअल प्रेजेंस, देयर आर वेज दैट थिंग्स स्टिल कैन बी डन. So anybody who has concerns with developers, you've got umpteen remedies. And we have, touch wood, with the grace of God, we've been very successful in getting people back their money along with interest, along with damages, and in a stipulated time. There are some cases which of course take a lot of time, पर वो matters थोड़े dicey भी हो सकते हैं, थोड़े confusing भी हो सकते हैं. There are too many nitty-gritties to that. But there are some matters which are very simple, straightforward. Seek your advice and get your relief. But don't assume कि हमने इंटरनेट पे पढ़ लिया तो उसमें ये लिखा है. No. हर केस डिफरेंट है, हर केस की रेमेडीज डिफरेंट है, every case has a different strategy to be followed upon. So I look forward to helping and assisting anybody, any person who needs help, who needs assistance for any issue you might have back in India. Thank you.
Thank you, Monisha. Can I see Nehal and Abhay back? So we must have seen that a lot of questions has been asked by our audience, and now if I start from the top, there are like the PAN card application, we have taken care of it. Then there is Abhay, if somebody while he was in India and he has applied for a PAN card and if he has moved abroad, does he need to reapply for it, or is just the same PAN card will work, and what the process in that case?
Abhi, you're on mute.
Thanks, Monisha. It is a straight answer to this is the PAN number remains the same. You don't have to apply for a new PAN card, even if it is you're a resident earlier and now you become a non-resident. But please take care that you need to shift something called as your ward, income tax ward. That has to be shifted from your routine resident ward to a non-resident ward. And that needs to take some kind of an professional help, as Monisha has been very nicely she has placed. हर एक केस का एक अलग strategy होता है. So this care needs to be taken by the professional. So the PAN card remains the same. The ward needs to be changed with the process.
Thank you, Abhay. Nehal, there is one question to you. What is the HDFC use as a lending criteria? How the loan amount can be assessed.
So there are a couple of factors on which the loan amount is decided. So first is your income. Second is your age. Third is your property value. What is the value of the property? Fourth is your obligation. So how many current obligations you have. And fifth is like, if you have any other dependents or any fixed costs associated with it. So there are a couple of factors, which decides on the loan eligibility. So, if you're looking for a loan or a mortgage, you please get in touch with us, as every case is different for everything, including law and taxes and loans. So yeah, we'll be able to help you with, your case specific thing. Yeah.
Thank you. Thank you, Nihal. Abhay, back to you again. There are a lot
Yeah.
of questions initially they asked about, what kind of money can be repatriated if there is a, PPF account or a bond money. There are a lot of sources of people have money and they want to bring it back. And also, I had gone through a question like if they are using that money for a purchasing property in UK or paying off the mortgages in UK, will that give you the tax exemptions in India or not? And what is a short-term capital gain as well? If you can explain
Let us
those.
take one by one, Mihir. I think so. One of the question that we need to completely answer about the repayment of mortgages. So let's take that way. The capital gains benefit is only given in the case when you purchase a house, or in the technical word, a residential property. You need to purchase a residential property. That is one. It doesn't help you if you repay your mortgages in India or outside India. Residential property has to be an Indian residential property. So it doesn't solve your purpose if you buy a property in UK, selling a property in India. Thirdly, when you say that any kind of receipts coming out of the capital gains can we repay, or we can, we may use it for some other purpose. But I have bought this house. There is one more clause we need to always understand, that this capital gains benefit can also be taken if you purchase a house within an eligible time frame, or maybe a 1 year or earlier. So it is not necessary that the same fund that you have received out of the sale consideration has to be applied for the purchase of property. You can make that fund utilize for your own, any other commitments. Take a loan, approach Nehal, take an additional loan and buy one more property. The criteria is only to buy a property. The criteria is not applying this fund what you have bought the property of. The next question I see there is Milan Kadiwar has asked 30% for less than 2 years is a short-term capital gain. The confirmation Milan wanted to know. 30% is the tax rate, TDS rate, at which rate your TDS will be deducted. For all time, the calculation for short-term capital gain would be, once you work out, it will be as per the slabs. Everybody would be aware. I'm not going to touch that point again. The slab, it may start from 10%, 20%, 30% for 2,50,000, 5 lakhs, 10 lakhs. So it will be taxed as per the slab. But the TDS, the buyer's responsibility to deduct TDS is at the higher marginal rate, which is 30%. TDS 30% पे कटेगा, आपका टैक्स जब आप रिटर्न बनाओगे तब आप उसको रिफंड में क्लेम कर पाओगे. There is one more thing which was asked is, are bonds available to NRI by Preeti? See, there are certain bonds which are not eligible for NRI to be bought, but this tax saving bonds, which we say NHAI, National Highway Authority of India, yes, you are eligible to buy even being an NRI and save tax under section 54 EC. Can repatriation of funds, as one more point Mihir was asking after going through a few questions was, what about funds coming out of PPF, from maturity of insurance? All these funds can be repatriated, as I have already explained, just repeating it once more. A chartered accountant certificate is needed. Your proof of that would be earlier years returns has to be filed, which depicts that this kind of income, which is an exempted income, like especially PPF and maturity from LIC, are the exempted income. But if you regularly file your returns, income tax returns for whatever income you receive in India, even though it is an exempted income, that gives a solid proof and easy route to the banker to issue them these funds back and repatriated, which can also be a support to the CA issuing a 15 CA-CB. So request you to please file your returns irrespective of the income is exempted or taxable.
Thank you. Thank you.
I'll just add here one thing to what Abhay said, because I deal with some of the bank account issues with people, of course, people who've died in inheritance money jinka hota hai. Now, what people are, it's become a compulsion in India, like I'm sure everybody is aware, that to set up an NRO account without an OCI, an account does not get a KYC. So people who've got money in fixed deposits or their parents' money in fixed deposits and wish to repatriate, they have to make sure that they have OCI so that at least their accounts, NRO accounts can be set up so that the money uske baad the steps follow for taxation advice, the form 15, then the money gets repatriated, because a lot of people think that they have old accounts, savings account hai, because purana, what used to happen is earlier people used to open their savings account because the interest rate used to be better here. So people would open savings account, and today there are still savings account, they've not been converted into NRO accounts, which is mandatory. So they have to first convert it into NRO accounts and then follow the rest of the process, and for which OCI is a compulsion. And like there is somebody who's also asked, like for selling of property, if they need OCI, yes, you will need an OCI not for selling, but to set up your NRO account and put the money in there.
Monisha, it's one more interesting question. I've seen that on a will, if a witness has died, then what is how they can manage it out? That's what somebody has asked them.
There have to be two witnesses, not one. Number one. That's the reason we say do witnesses kar lo, taaki one witness if one person dies. Now then what happens if one witness has died, let's say the lawyer who's notarized it for you, he steps in as a third person who can attest it in the court, who can stand as an attesting witness. And even if the lawyer is not there, then you need an affidavit probably from the family of the attesting witness saying that my husband or my wife went as a witness, she came back and told me that so and so person has died. But again, it is very strategic. You have to go case to case. It is not just, I am just telling you because this is something which happens when you're talking about wills which were dated back in the 90s and people are no longer alive. We've done that for people. कि उनके wife या husband या the children know about it, that this will was there, he had gone to the court or the lawyer's office to sign the will. So yes, that's how it takes place.
Now, there's one more interesting thing which I just come up the question. There's a lot of this myth about, people needs to have Aadhaar card. And what I understand that people who are living in India only required to have Aadhaar card. If person who is not living in India or a person is NRI or OCI, they have to have an Aadhaar card?
No. People are just, so what happens is there are a lot of offices, like we're getting a transfer done in Kolkata for a client where the Kolkata Municipal Corporation is stuck up कि जब तक आप आधार नहीं लेके आओगे, that there is this transfer mutation cannot happen. Whereas for an NRI, Aadhaar is not possible, and one brother, even if has, the rest of the children don't have. So then you move an application, tell them, and the copies of passport are a good identification document. Secondly is their PAN card. But I would just tell one thing, like Abhay would also agree with me on that any person who's got anything in India, please get your PAN cards made, no matter what, because that's one document which you will require, your OCI and your PAN card. उसके सिवाय कोई document होना हो, but PAN और OCI तो पक्का होना चाहिए आपके पास.
Even I understand, and even Neral, you don't ask for Aadhaar for as a KYC document. You ask for a NRI, means OCI and the passport. Yes. So Aadhaar is not at all required. People, please, I want to make to know, everyone knows that, a lot of banks do ask for the Aadhaar card and everything. But as a person who are living abroad, who are not a resident Indian, they do not require to have a Aadhaar card. So even I got queries that can you apply for Aadhaar from here and not? No, Aadhaar is only for the person who's living in India. So that one point is clear. Now, Abhay, one more interesting question has come up in a calculation of capital gains. If a person who is NRI or OCI who has traveled India to bought a property or maybe a registration of it, the travel expense can also be considered as a cost of accumulation.
I get this question a lot too.
Let us expand this question. So it is only the travel you're talking about, or the stay, or the food and the cab and the movie I'm going to watch there. So I need to ensure.
And the shopping don't miss when they come to India.
So let us be very specific. These are certain litigative points that you need to raise. You need to be very clarifying. Okay, this would be a specific incidental expenditure only for the property purchase. Those would be allowed. If we really want to be very adventurous with this, let's have a try. But from my side, as my opinion, no, it wouldn't be allowed for that.
Okay. And Nihal, the question to you, somebody's asked, if somebody has not identified the loan and approved the not identified the property and approved the loan from you, it is valid for how long?
It's valid for 3 months.
So it's valid for 3 months.
Yeah, and we can always extend it later. So if you shortlist a property, say the fourth or the fifth month, we can always reappraise your file and take your latest income documents and reopen the file. But yeah, it's valid for 3 months.
Okay. There is one more question. As interesting question comes up, that do we need a physical PAN card or e-PAN is sufficient?
E-PAN is sufficient.
Take a print of
My
that.
perspective is also, I hope Monisha can answer that.
Sorry, I just said take a print of the e-PAN card. That's as good as and get it laminated. As long as you have a PAN number, it is validated, and you have a phone number where you can get an OTP, I think it's good enough, and an email. That's it.
Now, looking at this question, rather let's see the perspective. If the person wants to go to the bank and ask them, okay, verify the originals, then the banker, as a banker will always say, original dikhao humko. So you need to take some proper printout which is convinced to that person who's sitting on that seat. In the perspective of just preparing a documentation for filing the returns, e-PAN card is sufficient for us.
Yeah.
And
banks, banks के साथ सिर्फ ये होता है, with banks they're still stuck up, like he said very well. Though you go to a national bank, they'll be like आप पहले original लेके आइए and वो लेके आइए. So as it is, PAN and Aadhaar are both available online, so you can get a nice printed copy and take it there. They'll be happy with that.
There's a very basic question, but it's a very valid question by people. People want to understand the difference between the accounts, right? NRO, NRE, and the ordinary or saving accounts, what we talk about in India. So if Monisha or whoever wants to take up the answer to this, that would
here I will hear Mihir. First, I will put some request to you. So when you conduct such kind of seminar again, I look forward that we should also have a banker, because people are more keen to see कि bank से पैसे कैसे निकाले जाए. So we'll have that there would be the from the horse's mouth to exactly explain us that NRO, NRE, repatriation forms. There are a lot of A2 and A1. A lot of different forms also involved beyond 15C ACB. A lot of technical things, but let Monisha take this up. About the NRO, NRE account. Monisha, will you like to?
Yes, I would. In fact, Abir, I think the reason he has me here is because repatriation of funds for inheritance money happens to be our core area of service. So that's the reason he says anybody. So okay, NRO account and NRE, two accounts, bilkul different accounts hai. Generally, when you come to India and you open an account, you say I'm NRI, the bank opens both the accounts, whereas you can open only NRO or NRE, दोनों नहीं जरूरत होती. NRO, as the name suggests, rupee account है, जिसमें आपका India money is there. When you talk about an NRE account, it is a foreign currency account, जिसके अंदर if you are sending money from UK, you can directly park your pounds or you can directly park your dollars in an NRE account. Whereas anything in India, it's happening in India and it is coming in Rupaiya or Gandhiji, then it is the NRO account. So these are the two different accounts. Now for an NRI, a non-resident Indian who stayed out of India for more than 182 days, he needs to have an NRO account. The savings account, maybe you stayed in India 10 years ago or 5 years ago, you were a student, as a student you left for your country and then you started working, please get your accounts converted to an NRO account. Just in case verification hoti hai, sab kuch hota hai, get your PAN card sorted again and your account from savings to an NRO account because it's compulsory. Now, mostly people start feeling, why are people asking this question also ki savings se hum NRO mein convert karaएं, is because of the rate of interest. Rate of interest and the tax deduction which happens by the banks automatically. That you should take an advice of a chartered accountant on that, but compulsorily, NRO is these two accounts only for NRIs. One is your foreign currency account, one is your rupee account, and a person who's lived and gone and had a savings account, get your account converted into an NRO account. And for which you need a PAN card and an OCI अगर वो पैसा कभी बाहर लेके जाना है.
Okay, I got it. And the lot of questions are coming regarding the filing of tax returns. They're saying if I just have a no income in India, or if there is only interest income on a bank account, still do they require to file a tax return in India?
No, they don't need to, but it's always good to file a zero income return.
Okay, fine, fair enough. So it is always good to file because that can help us the source of fund, where it is coming and everything.
As I addressed earlier, saying that the filing of returns is a good support for accumulated funds in your account. So all your interest income or even the tax-free income if you file it in your income tax returns, that gives you a summary of records for the accumulated funds which is been intended to repatriate. So whatever the funds been accumulated, that gives a good support that this entire fund is being taxed, is been declared to the government, and the banker wouldn't have any challenges to repatriate. So please request everyone to file their returns every year.
Yes. Even I would suggest that file your returns, because कल को repatriate करना है आपको background, it becomes easier to just put everything in a booklet and submit it to the taxation authorities rather than doing a complete letter as to why the returns weren't filed and so forth and so on.
Monisha, there is one interesting question I've going through. I found that a gentleman has invested in a commercial property in NCR, and it is a mixed use development, commercial and residential. And the property has gone into a litigation and everything, and it has been taken over by Supreme Court and all. And the Supreme Court is giving preference to first to the residential property, then the commercial property. So what is he want to understand? What is his stay for his commercial property? How he's going to approach on that part of it?
See, as long as the court will always give a first preference to people who've bought it for residential purposes, because that's a personal requirement. Commercial becomes again commercial use, and that is the reason. So first preference, but you'll still be in the preference list because you're an investor at the end of the day and you're a secured creditor. Now, once you are so what I would suggest for people, a lot of people do that thinking कि अभी तो court में उन्होंने bankruptcy file कर दिया, what happens? Now, I remember some people, we worked for Supertech. So people did not want to file a claim because Supertech was under litigation. They were in the Green Tribunal then until an order was passed by the Supreme Court. And I kept telling them, file a claim. The day you get an order from the court, we can at least, if they are declared bankrupt or they go in liquidation, you can at least put a claim form and get your money, because you're amongst the few people who are who can get back their money. So maybe not the interest, but at least जो आपका principal money है वो तो आएगा. So there are some people who've been able to get it, and there's some people I still know who still call me up now. What will happen? They've already been declared bankrupt. अब तो पैसा कभी मिल नहीं पाएगा. So something which I told them probably 3 years or 4 years ago: file your claim, get your money back. Similarly, for this gentleman who is invested in a commercial property, please file your claim. And then उसके बाद जो order होता है court का, they will be bound by the order. Let them be in litigation. That is a separate litigation between them and the authorities. But what you are doing is separate, because you have invested your money and it must have gone through proper banking channels, so forth. You must have an agreement. So you will get your claim. Now, the execution of the claim will be secondary, but at least आपका claim should be stamped by the court कि yes, you can recover this kind of money from them.
All right, thank you. So who have asked, please, if you need any further assistance, please contact me or Monisha, and we'll help you out on that. The one more interesting question has come up by what is the, when we're talking about the capital gain, if somebody is selling the agriculture land in India, what is the law so about the capital gains and all?
I think agriculture land would have been acquired when the person would have been resident.
Yeah, inherited to the person if person is not a resident. So then in that.
I understand. Now here the agriculture land has been, as per income tax, there is a definition of rural agriculture land and urban agriculture land. So if the land is falling under the category of urban agriculture land, it is taxable. If the holding is more than 2 years, the eligible period. If it is a rural agricultural land, then it is totally tax-free. It is tax exempted irrespective of a resident or a non-resident selling the land. Agriculture land definition is as per the Income Tax Act. There are specifications about the number of the population in that particular area. If वो municipality radius में 10 किलोमीटर के radius में आ रहा है कि नहीं आ रहा है, वो particular area का कितना population होना चाहिए. So those criteria, if those have been fulfilled, then the agricultural land is an urban, and it will be treated as a normal immovable property, and the rest of it falls accordingly. But if it is an rural agriculture land not falling into the categories of municipality radius mein hai, then it is an exempted income if it is held for more than 2 years. But there one more point I need to just touch upon, since you have used the word inheritance. Here the cost of acquisition, people may have this question that what would be the cost of acquisition if I inherit my property from my grandparents or from parents. Here the cost of acquisition, because we have an inheritance, you don't pay anything, but the amount which was being paid by the original buyer will be considered as cost of acquisition. And the period will also be considered from the date from which the original buying of that property was made. So if I inherit my property 2 months before, but the holding by the original buyer or the owner was 5 years, and if I sell it after 2 months, I still fall into the category of long term, and all the cost of acquisition being paid by the original buyer will apply. Deducting for the inheritance के लिए मुझे जो खर्चा लगा, I can add to that as my cost of improvement and claim that is an expenditure also.
Okay, thank you. So somebody have just messaged me also and asking me, we are talking about all the capital gains about the property, but if somebody wants to invest in a mutual funds or a SIP, and if they want to sell, what the rules is same for both resident and non-resident, or it's a different, or how it works?
This is a very general question. What does it mean by the rules? The rules of capital gains, the taxability?
Taxability, yes.
The taxability.
Percentage, the rate of tax that is payable. So the tax that is TDS is what they're going to be deducting, because जब आपको पैसा आता है तो TDS तो automatically deduct होता ही है.
So for the mutual fund securities, the tax rates are different. It is not the same tax rate which is for the properties. It is 15% when you go into the long term, and indexation benefit will jata hai to 10% hai. So the TDS for all purpose, because the TDS is falling under section 195 for NRI. So section 195 always states that this is an overriding section to all the other TDS sections. So in any other section, if the tax rates are lower or higher, for an NRI, you have to follow section 195. In 195, the TDS rates are normally the highest marginal rate on the sales consideration. So आपने अगर mutual fund बेचा है, if you have sold it for 1 crore, it will be deducted tax on 1 crore, and unless you go and apply for the lower tax deduction, or you go and file the returns, and then you can claim the refunds for the higher TDS deducted. Mutual funds tax rates are different. When you sell securities, the tax rates are not 20%. They are different than the property sale.
All right. Thank you very much. I know there are a lot of questions are there, but we are running out of time now. And I would like to personally thank everyone to attending it. And still, if your question, I'm sorry if your question has been not answered, then please drop a line or message to me, and we will take one-to-one your questions and queries, and we'll help you out to do if anything required action to be done. I would like to thank you, Monisha, Abhay, Nehal, for all your valuable knowledge to share with everyone. And if anything required, please contact us.
Okay, guys.
Thank you.
Thank you, Monisha. Thank you, Nehal. Thank you, everyone.
Thank you, everyone.